Good morning, everyone. Welcome to the fourth Lunch and Learn from GSU. My name is David Girard. I'm the Senior Union Representative. So today we are going to look into when the employer misbehave. Can we grieve Article 1 of the collective agreement that talks about harmonious relationship? So the short answer is no. So why is that so? It's the court and the board. So the arbitration board has determined that Article 1 is an introduction article. So it's a general clause or a preface that did not grant any substantive right to employees. So in another case, we have an adjudicator that um, decided that Treasury Board workplace harassment policy was consistent with the objective of Article 1. The federal court, upon reviewing that decision, decided that he has misinterpreted the article and exceeded his jurisdiction. The grievance should be dismissed. So the jurisprudence consistently since then consider that Article 1 does not provide substantive rights to employees in the sense that we can file a grievance against the employer not maintaining harmonious relationship. It's important to note also that this article is between the employer and the union. So we're not talking about a situation, and we don't have such grievance where the employer as a whole would try to have overall not harmonious relationship with the union and not necessarily the griever. So we might be in a position where we would need to make an analysis on a potential policy grievance, but it's not the case here. We're really talking when the employer misbehave in the workplace, what can we do for grievers? Um, so why are we using Article 1? Okay, so most of the time we're using Article 1 because we cannot find anything else in terms of violation of the collective agreement. So we go in terms of harmonious relationship. Um, Most of the time, it's because of harassment. So we're using that article for harassment situation, and more specifically, what we call personal harassment. What is personal harassment? It's basically any harassment that is not discriminatory. So that is not based on one of the ground of the collective agreement or the Human Right Act in terms of discrimination. So you're discriminated against because of a disability, because of your family status. So those are discriminatory harassment. For personal harassment, we don't have any provision in the collective agreement for Treasury Board. It's important to note that the MENT, the personal harassment is included and can be grieved. So what's the proper recourse then when someone is facing personal harassment? The proper recourse would be to file a violence in the workplace complaint as per as part 2 of the Canadian Labour Code, and also file non-adjudicable grievance for personal remedies. So personal remedies is what, like, someone needed to take time off and wants their leave to be reinstated. So that's the type of grievance where we have a chance of resolution through the grievance procedures before arbitration, especially if the harassment is founded when we follow through the violence in the workplace complaint process. So as a steward, what you need to do is try to determine and understand if when you read a collective agreement, is there a right there? And who does the right belong to? So Article 1 is not the only um, provision in the collective agreement where we have, the board, adjudicator, and court determined that there is no substantive rights. One of the other example is the article on health and safety. In Treasury Board collective agreement, the article reads as follow. The employer shall make reasonable provision for the occupational safety and health of employees. The employer will welcome suggestion on the subject from the alliance, and the parties undertake to consult with a view of adapting and expeditiously carrying out reasonable practice procedures and techniques designed or intended to prevent or reduce the risk of employment injury. So the board make a determination that most of the time, because there is always exceptions, most of the time another administrative recourse exists for health and safety, and those recourses are in the Part 2 of the Canadian Labour Code, which might be comprised of the violence in the workplace complaint mechanism or a right to refuse dangerous work also. Um, so the once again, board has determined that this article does not provide substantive rights to the worker. So the article talks about the relationship between the employer and the alliance. So in terms of personal grievance right, most of the time we could not file a grievance solely on Article 2201 of the collective agreement for Treasury Board units. Um, what else? So we have a lot of concern within our membership with performance evaluations. So the alliance has tried in the past to push a grievance regarding employee performance review to the board. And what they did is they have used the article in the PA table is the article 58, and they have used specifically 5801A, which is a definition. For the purpose of this article, a formal assessment or appraisal of an employee performance means any written assessment or appraisal by any supervisor and how well the employee has performed. The employee's assigned tasks during a specific period in the past. Um, so we've tried to argue that the criteria that the employer has used was improper. When this grievance was pushed to arbitration, the board determined that the arbitrator determined I'm not persuaded by the griever contention that they support the proposition that a definition clause of the collective agreement can in and of itself found adjudicatory review of a performance evaluation in the name of flawed process. Okay, so it's important to understand, and that's something that we usually know. So we cannot grieve necessarily the content of a performance review up to arbitration with the current wording that we have in the collective agreement. We have rights as per Article 58. So the person that evaluates you needs to have knowledge of your work for at least half of the period for the evaluation. But in it itself, to go after the content, board determined that we cannot go there right now. Okay. Um, Another thing that the unions have tried in the past is go after the objective of the workforce adjustment appendix. So in the objectives, um, so after the objective themselves. Okay, so the arbitrator in one of the cases agreed with the employer argument that they don't confer substantive rights on the griever. However, the griever was claiming that the employer refused um, uh, an alternation job. So the grievance will ultimately upheld because there was elsewhere in the workforce adjustment appendix that was talking about the employer discretion on those alternation, and the educator found that the employer did not use his discretion properly. Um, One tips is when you are grieving, when you're filing a grievance on behalf of a member, try to avoid to specifically point to one provision of the collective agreement or one subsection. I'm grieving the WFA appendix, Article 1, subsection B, triple E. Okay, because then we're stuck with exactly what you just said. So if you have an issue with the workforce adjustment appendix, in the wording, it should be I'm grieving at the employer contravened the workforce adjustment appendix. Okay. Same thing with Article 19, no discrimination. I'm grieving that the employer breached Article 19. You don't need to go into Article 19.01 on the basis of. So the basis will be there in the wording to because we need to know what we're talking about. But in terms of the grievance wording, be more general than specific. Okay. Um, so in conclusion, Article 1, if we go back to Article 1 or any other article of the collective agreement, if the article does not provide substantive right to the employee, they cannot, and you should not file a grievance solely on that article, or you should not mention it at all because it doesn't hold any value. Uh, just what I wish to remember you that we have a process at GSU. If you are unsure, say, what should I do or what should I not do in terms of filing a grievance? I cannot find the proper article. Please refer to your local president. Local president maybe have dealt with this in the past, and if he or she has not dealt with this, they can refer to the RVP, and the RVP also have access to the national office resources. So never hesitate to escalate this and to ask someone else, hey, what do you think here? What could we do to help and support the members? So thank you all for participating. If you have any questions, I'll just wait a few seconds to see if anything pops up in the chat. And if not, I want to wish you a great day and see you next time. I see nothing. Thank you. Bye-bye.